Walshe Judge has no problem holding Norfolk County Milkmaid, McLaughlin's feet to the
fire
as she seemingly continues to play hide the ball with Michael Proctor's iCloud account.
We have somebody that's assigned to this case that has access to those materials by virtue of the fact that you were assigned to the Reed case. And you have knowledge of this case by virtue of your affiliation with the case and your prior stuff that I said. Why isn't the easy first step for everybody other than you in the courtroom who has to do the man hours, for you to make that analysis and at an initial matter say there is or is not something in the materials?
Hello, and welcome back, roommates, to another titillating edition of Alexasrewm, where we are not lawyers, we are not medical professionals, and we are not law enforcement. We are just people. People who have opinions about all things going on post-Karen Reed verdict, including Norfolk County Milkmaid ADA McLaughlin. It's really good for the throat, especially it's allergy season, you know. Whose unironed blazer you may recognize from season 1 or 2 of the Karen Reed case, is attempting to play a rousing round of legal limbo with Rule 14, which Walshe Judge is having none of.
Outside the protective order, defense counsel and the Commonwealth had to seek that information. I provided date stamps, numbers to counsel, and they had to go to the U.S. Attorney's Office.
But I'm suggesting that in this case, you do that first step.
And that, I would say, has been done, and it's sort of in a similar posture where we represented to counsel that you need to file 2 requests. Counsel filed a 2 request, the Commonwealth filed its own 2 requests. The U.S. Attorney's Office denied that.
But the difference is, in the other case, you identified a document that you believed. What I'm asking the Commonwealth to do, and I'm asking you to do it now in light of the new rules of discovery, not the ones that may have applied when you did it the last time,
Yes,
is to review those materials and identify whether we even have something to worry about.
So we talked about the federal protective order before. That essentially sealed any information that was gathered during the federal investigation of the death of John O'Keefe, which includes what was found inside Michael Proctor's Pandora's box, right? His iCloud account. Now all of these defense attorneys want a piece of the pie, see if there was anything nefarious that he was texting his buddies about or his superiors about in regards to their clients. There was a destruction order that they were told the Commonwealth needed to comply with a day before the supposed destruction of these copies were supposed to take place, which again included contents found in Proctor's iCloud account. There was a hearing about this last week, which extended the destruction order for the federally protected materials that were sealed. That was extended by a week. Since then, there's been a new filing, which was dated yesterday. Ted Daniel from Boston 25. The Norfolk DA's office says the destruction order has been extended by 30 days. Okay, so instead of them just having a week to shuffle through everything and figure all the shiz out, now the Commonwealth has an additional 30 days to see if there's anything mandatory, exculpatory. I'm a poet and I didn't even know it. They need to disclose to the defense of all of these over 24 cases associated with Bear in the Big Blue House. So I'm assuming, again, this is all the same shiz that has been circulated around for every attorney. Commonwealth files the following notice as directed by the court, Judge Krupp. On July 18th, 2025, the United States Attorney's Office obtained an order from the Federal District Court, Judge Casper, dated July 21st, 2025, so a couple of days ago, which grants the Norfolk DA's office an additional 30 days, so 30 days from the 21st, I'm assuming, with the return or destroy provision of the federal court order previously issued by that court on December 2nd, 2024. Based on the information provided by the USAO to counsel to the NDAO, the 30 additional days run from July 18th. So, excuse me, I spoke too soon. From July 18th to August 18th. The July 21 order further provides that the NDAO may disclose the protective order to the state court and defense counsel in any criminal matter involving former Massachusetts State Police Trooper Mr. Chocolate, provided that the protective order is filed in the state court under seal. So everything's got to be hush-hush. It can't be outed to the public. As of the filing of this notice, it is the intention of the NDAO to file the July 21 order and protective order under seal and request a state court protective order in each pending case involving former Massachusetts State Trooper Chip. The NDAO will provide a copy of the protective order and the July 21 order to defense counsel after the state court endorses a state court protective order.
It seems to me that ADA McLaughlin is one of the signatories on the agreement.
Don't be saying Laura McLaughlin's name 3 times in front of a mirror at midnight, because her and her unironed suit may just appear.
As a result of being on the Reed case, and it seems to me that she is on this case, was in the grand jury throughout the 11 or 12 days of the grand jury, so she's intimately familiar with what happened in the grand jury.
Yes, she has bumped uglies with Michael Proctor's iCloud account. She knows what's on them. She's seen it all.
And otherwise is intimately familiar with what this case is about because she's still on this case. And being in that unique role as being A, someone who can look at the materials, and B, is assigned to this case, it would seem to me that she would know whether or not there were any materials that were required under Rule 14 and the case law to be produced in this case. And that situation does not replicate itself in all of it. I don't know if it replicates itself in any of the other cases that people were involved with Judge Krupp last week. I don't care about those cases. I just care about your case, this case. So it would seem to me that with that pause, I understand that Judge Casper has put a 30-day pause on everything for people to assess.
So she knew about that before this hearing. So that, like I said, we just went over that. That was filed yesterday. So I think everybody was aware of that 30-day extension at this point.
The situation, and it seems to me that what needs to happen is that ADA McLaughlin, who has access to that information, needs to determine as an initial matter whether there is anything in those materials that would be required to be produced under Rule 14. And if there are, we'll deal with that. And if there aren't, then the Commonwealth needs to aver by, think of a bunch of different ways, affidavit or otherwise, that there aren't any. Now, the backdrop to this is, as we know, and I'm not going to get the exact language correct, but when we asked for a TUI request earlier in this case, we got we're not giving it to you, but by the way, there's nothing there. That's my paraphrase of it. But that doesn't relieve the Commonwealth of its obligation. So that's how I frame the issue in my mind right now for this case. And I guess it's the defendant's motion that brought us here and alerted me to the issue. I mean, the Commonwealth gave me an email before that, but Attorney Tipton, what do you think about that?
So we went over their motion in one of my last videos, but just to refresh your cranium. So they're saying that the Commonwealth represented to them that they don't know what materials, or at least one of the ADAs who's working on this case, doesn't know what materials produced to the Norfolk County DA's office at issue are in fact, since this person, so this particular ADA, was not a signatory on the protective order and has never reviewed them. They don't name the ADA that they're referring to, but the signatory, as we just learned, is McLaughlin. Council filed a 2-year request for federal materials, but that request was denied. In summary, the U.S. Attorney's Office denied a request by stating, 1, it was not aware of any statements by state or local law enforcement in possession, custody, and or control of my office or the Federal Bureau of Investigation that concern the investigation of Mr. Walshe for his wife's unaliving, for the Walshe unaliving case. Which is why she's saying, this might have been what the U.S. Attorney's Office told you, but that still doesn't change the fact that the Commonwealth needs to do their due diligence, review all these materials so that they can comply with Rule 14, sign that little certificate of compliance, right? That some of our requests fail to meet the specificity requirements of yada 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 or fall within one of the exceptions to production in yada yada. And that some of the requests, if responsive, would have been compiled for investigative purposes and would interfere with an ongoing investigation. So either, again, there is nothing, it's a whole lot of hoopla, or there is shiz. And the feds can't provide it to you directly because of a potential and ongoing investigation, which would be within the matter of the investigation into the death of John O'Keefe. So, again, which we talked about, I mean, is there still an investigation going on? Did Hank lie? Yada, yada. So, just to give you some context.
First, Sean. Attorney Porges.
So I had a brief discussion with the Commonwealth this morning, and my understanding is that they're filing a request to impound the protective order in which they would show it to the court, show it to us.
They did.
Okay.
Did you get that before the hearing?
We did. So we have the protective order. So our main concern this morning was asking the court to order the Commonwealth to review the material for any exculpatory material or issues. If the court's inclined to do that, then I don't need to be heard further. I would just highlight that a case came down just yesterday that is decidedly on point with this issue. You're smiling because you know, or you're smiling because you know?
I think I know.
Okay. It's Commonwealth versus Goparian, and I would refer everyone to the section that discusses possession, custody, and control. Furthermore, the new revised rules under the Mass Rules of Criminal Procedure do a very good job of clearly explaining and expanding what exculpatory means. And in this situation, they are arguably in the possession of federal grand jury material that was investigating not only Trooper Proctor, but possibly the integrity of a murder investigation done by this very county, by these very officers. And so I just want to be clear that if the court is going to order it and the government is going to accept the order, that we want to make sure everyone has the same understanding of what exculpatory is. So otherwise, I have nothing further unless the court has any questions.
I mean, if you want, we can provide Webster's dictionary for you, McLaughlin. Because I don't think your department really does know what mandatory exculpatory discovery means, right? This woman makes how much money per year? You can't afford dry cleaning? I don't understand.
So it's kind of a unique posture because my co-counsels are not party to viewing the protective order at this juncture. So First Assistant Lisa Beatty has been in contact with the Special Assistant.
What does
Attorney
supervisor mean?
That would have been the chief of the appellate unit at that time who signed the protective order in 2024.
But it says.
So the protective order, okay, this answered my question from last time. The protective order is from 2024. So I'm assuming there was only one protective order that was evergreen, ongoing, through the second trial, right? And this is how more drips and drabs of X, Y, and Z. Insert missing Sally Port video with Brian Higgity Diggity here, yada yada. And you were a signatory on this order. You had to have known when the expiration date on these materials were. And like, oh, I got too busy. Right? Meatball, he's a busy guy. Stuffing raisins into his ground beef. I get it. Hobnobbing in parades that nobody goes to let everybody know that, hey, by the way, your order's about to expire. And these materials that you haven't even gained access to, which you might have a right to access, are going down the digital drain in T-minus 24 hours. Thought I'd give you the heads up. Like, they're all just snakes.
Is that right?
That was the way.
Hold on a second, I just want to go back and see what the. So I refer you to 6B. What is that?
When that was drafted, it was relative to supervisors assigned as part of the Karen Reed prosecution.
If the investigation's closed, why would you want to keep this shiz under seal? Proctor's already canned. He's already out the door. He's not your problem. What, you don't want people seeing more of Cheesy Banana's Cheesy Banana? His digital fingerprints and footprints and God knows what else? Up and down whatever thread he and Chip and Bukwaki were gossiping on.
Now, just add, the case that came down yesterday is distinguishable because in that matter, the SJC said that the DA's office did not have those materials, that federal materials in a, perhaps a protective order remain in the custody of the federal government. That case is distinguishable because a Worcester police officer participated in the interview and had personal knowledge that he could have discussed or disclosed to the ADA, that the ADA did not pursue that information that would have been held by a Worcester police officer. It is distinguishable that pursuant to this order, the materials do remain in the care, custody, control of the federal government, and the DA's office is just prohibited from any further disclosures.
So what of my suggestion with regard to your role?
That is a role I understand. That is a role I can represent to the court in a different matter. Upon my review of the materials, I saw a statement that was clearly exculpatory in a different case. I spoke to the U.S. Attorney's Office about that matter and had to advise defense counsel and trial prosecutor in the office that they needed to seek a TUI request.
So that's what she's saying. So Hangnail is like, okay, I apparently reached out to the U.S. Attorney's Office, and we can only take her word for it, right? Like, I'd love to know, where's the documentation of this? How was this communicated? Did you phone them up? You meet in person? What'd you do, Laura? I spoke to them. Take my word. Trust me, bro and bro-chachas. I'm not saying that she's necessarily lying, but Girly Pop does know how to bend it like Beckham.
Right.
I could not disclose that directly. The U.S. Attorney's Office did not produce that outside the protective order. Defense counsel and the Commonwealth had to seek that information. I provided date stamps, numbers to counsel, and they had to go to the U.S. Attorney's Office.
But I'm suggesting that in this case, you do that first step.
Yeah.
And that, I would say, has been done, and it's sort of in a similar posture where we represented to counsel that you need to file a TUI request. Counsel filed a TUI request, the Commonwealth filed its own TUI request. The U.S. Attorney's Office denied that.
But the difference is, in the other case, you identified a document that you believed. What I'm asking the Commonwealth to do.
Right. So the Worcester police officer that you were just talking about, you identify as, oh, this is exculpatory evidence that he's aware of. I found this within the materials that have been under federal seal in this protective order. I need to let them know that, hey, I found something. whether or not the feds want to hand that over or not, because it may or may not conflict with an ongoing investigation, which sounds like at this point there very much is. Like, this is what I'm gathering from all of this. Hank Brennan isn't just a weasel, but he's a liar. And what she's saying is, instead of asking the U.S. Attorney's Office to go through all of this stuff, because they're not the ones with a Rule 14 obligation, you are. This is a state case. They don't give a duck. Do your job, hangnail, and thumb your way through this discovery, and if you find something, if you see something, say something. And then we'll cross that bridge when we get to it. Cut your dang toenails.
And I'm asking you to do it now in light of the new rules of discovery, not the ones that may have applied when you did it the last time.
Yes,
Is
Your
to review those materials and identify whether we even have something to worry about.
And the understanding would be trying to, without knowing the defense theory of the case and seeking the broadest, what is most
That's
favorable
always
to the
your
defendant.
burden. That's always your problem. I mean, you. It's always the prosecution. I mean, they make that argument, I don't know, a couple times a week before me when I'm sitting in a criminal session. They can't possibly do as good of a job as me. And yet you have to. That's what the rules require.
Get over it, girl. Like, that's the law. Now, of course, if this was Bev's Playhouse, we all know that she'd be throwing back a couple of White Claws and getting a little bit frosty right now with the defense for even possibly making her entertain this idea. I think this would have been like, oh, well, I'll review it. Oh, you filed a 2B request and the U.S. Attorney's Office said no go? You can't get your hands on this? Sorry, tough luck. The Commonwealth did all that they could. In my opinion, that's how it probably would have went down, which is scary to think about because Beverly Canola Oil, I do miss saying her name, was the original judge assigned to this case before she had to turn things over to this judge. So I'm excited to see how this unfolds. I don't think earlier in this hearing they were arguing the motion to dismiss. I don't think the case is going to get dismissed. But I think the Commonwealth's definitely going to have a harder time proving their case, even though, I mean, it's very, very likely that Brian Walsh did unalive Anna Walsh, but, you know, we'll see how that all unfolds.
And I understand my obligations as a prosecutor to do that. It just becomes a difficult conundrum where if there was...
Wait, what did you just say? Hold on. Backing that up.
And I understand my obligations as a prosecutor to do that. It just becomes a difficult conundrum where...
Do you take, like, vocabulary lessons from Hank Brennan?
If there was a matter, I cannot disclose it to defense counsel, and I cannot disclose it to the court.
I
due to the
understand that.
restraints of the order.
I understand that, but why is it not I don't want to say an easy first solution. It puts a huge burden on you. I don't know how much materials there are in there.
Who cares?
But why isn't it the first step that we should be taking here is we have somebody that's assigned to this case that has access to those materials by virtue of the fact that you were assigned to the Reed case. And you acknowledge in this case by virtue of your affiliation with the case and your prior stuff that I said. Why isn't the easy first step for everybody other than you in the courtroom who has to do the man hours?
And you're probably going to get paid a hefty load of overtime, so you can't even complain. With that overtime, maybe you could buy yourself a new suit, get yourself a blowout, I don't know. But if you had these materials since, 2024? And I understand the focus was the Karen Reed case, right? And that's what you were probably mainly going through all of this discovery for. Certainly, as you're going through everything, if you see something, you're flagging it, right? Just to save yourself a little bit of the man hours. Do your frickin' job. That's what taxpayers pay you for.
For you to make that analysis and at an initial matter say there is or is not something in the materials that we need to disclose.
And I can represent to the court that the materials that were produced are related to the investigation of the death of John O'Keefe and not any materials related to the investigation of the death of Anna Walsh.
All right, well, I appreciate that. That's falls short of what I'm asking you to do, which is to avert to me, probably by affidavit, that there is or there is not information in, I understand their focus was on there. That doesn't mean that something doesn't make its way in to that file and those records. And I want some assurance that somebody has laid eyes on those documents and recognizing that it might be unlikely that there's anything to do with this defendant in those records. Close that door.
Yeah, we're not just going to take your word for it, Laura. I want signed proof. Put your name to an affidavit. Put your money where your mouth is.
And to do so, Your Honor, I believe we would have to seek guidance from the U.S. Attorney's Office to make sure it's not outside the confines of the protective order. Because the way the protective order says,
well, the
you know,
order
some
allows you
release
to
and things
review
like
it,
that.
right? The order allows you to review those materials.
For use in the state court action against Karen Reed.
But you already reviewed them. And like I said, as you were reviewing these materials, what were you doing? Twiddling your thumbs? You weren't paying attention to anything that came up through your review, the first few go-arounds? You probably are very familiar with everything in that data and digital dump. You could probably recite it in 4 different languages if you really wanted to. So why is this a problem now? Why didn't you flag it as you were chipping away through your review for the Karen Reed case? Because you're trying to get around it on the technicality, in my opinion.
So have you sought guidance from the court with regard to for review in connection with any other cases?
I believe that is what ADAPD has represented with, where the Commonwealth can't represent itself in federal court, a assistant attorney general has been appointed, and I believe there is ongoing discussions.
All right. Headed to another meeting on this, probably next week, because I don't want this to, I'm not going to put this out till the 30th, the 30 days, and we're in another fire drill.
So essentially what happens here is I believe they agree to meet again on August 1st, so next Friday. Hopefully we'll have another clear stream like this by Boston 25. I'm sure we will. As this progresses, if there is discoverable material that the defense is owed from that iCloud account, and the DA's office is trying to skirt around their obligations, it's not going to look good come trial time. Because I don't think this judge is having any of it. She's not like Bev where she's like, oh, I need to have a think on it. Let me pop a Valium, slurp down a claw, and have a little bit of a lie down. Ruminate on it, only to passively aggressively follow up with a handwritten note saying denied with no explanation. Like she's going to get this figured out so that this trial doesn't get continued. But I want to hear your thoughts in the comment section below. And on your way out, if you enjoyed today's content, hit that subscribe button, hit that notification bell so you don't miss the next video from me, and make sure you hit that like button. That tells the YouTube algorithm that this is newsworthy news. It is. A lot of this isn't being covered by mainstream media, at least not as aggressively as a lot of the independent journalists and content creators on the YouTubes and Twitter X's are. This needs a brighter light shined on it because it's all relative. It's all tied to the fact that these guys in these positions of power have been on rinse, repeat, recycle for probably decades, pulling the same kind of shenanigans that they did in the Karen Reed case, with all these other cases, and it's sick, needs to stop. and there needs to be change in Norfolk County. So thanks so much for watching. Have a great weekend.